keynote address. We're now going to turn to our first panel of the day. So welcome and thank you for joining us to Dr. Ivanka Antova and to Mairead Enright. Our first panel today at the Women in Law Conference will discuss the theme of advancing social justice. Sadly, one of our speakers, Ursula O'Hare, has had to withdraw through circumstances beyond her control. However, we are lucky enough to have two speakers with big enough experiences between them to fill an entire conference, never mind a single panel. We're going to hear first from Ivanka. So Ivanka is an absolute powerhouse of a social justice advocate. She is currently Research Officer for the Northern Ireland Human Rights Consortium. Ivanka is a human rights campaigner and activist with a particular focus on the rights of disabled people and the rights of migrants, of refugees and asylum seekers. Ivanka has been the convener of the Belfast branch of United Against Racism since 2018, and we, her friends and former colleagues at QUB Law, were rightly proud of Ivanka when she was recently awarded a Racial Equality Champion of the Year from the Northwest Migrants Forum. So before Ivanka begins, could I please remind everyone to mute your mics while the speakers have the floor, because the feedback can be quite disruptive whenever they're talking. Thank you very much, and Ivanka, it is over to you now.
Thanks, Claire. Thank you very much for inviting me to be on the panel. What an introduction. Thank you for this. I will proceed to disappoint everyone for the next 20 to 30 minutes. And please give me a shout when it's close to 20 minutes, because obviously I can ramble on for a long time. So hi, everyone. I'm Ivanka. I'm Bulgarian. I'm an ex-QUB research fellow, now working over in the Human Rights Consortium. Currently working on examining the impact of Brexit on human rights in Northern Ireland, which is it's not fun, but someone has to do it, I suppose. The panel today is on advancing social justice, and I want to say nice and early that I don't have major experience in actually achieving social change through my work as an academic, as a researcher, or as an activist. But I do have experience in dedicating my work, both my professional work and my activism, to the struggle for advancing the rights of marginalized communities. My experience is limited, but even I know that this is a long-term struggle. The struggle for justice, the struggle for equality, the struggle for voices which are normally silenced, to be heard and to be put in the center of discourse. That's a long fight, that's a long struggle, an ongoing one. So I suppose I'm just making little contributions here and there as much as I can. I will give you, I suppose, examples of how I've used my legal education to contribute to the struggle for social equality. But first, I wanted to say a few words about my approach as a professional researcher. I've been a researcher in both the academic and the non-governmental sectors. And the one thing that unites my bit of a patchwork of work activities over the last few years is that same attitude. It's really blurring the line, either for good or for bad, between professional and personal and political. For me, everything is a mixture. My work, the academic work that I've produced, I would argue, is very political, whether I've written on the rights of disabled people during the welfare reform unleashed upon us by the Tory government, or whether I now write on the potential for human rights devaluation and destabilization in Northern Ireland as a result of Brexit. My academic work is very political. And I also bring a lot of my personal politics into my professional writing. As a PhD student in the School of Law at Queen's University Belfast, for example, I was writing on the welfare reform policies between 2010 and 2015. You know, anybody who's written a PhD knows they kind of have to limit yourself to something. So that was my time limit. It was those Tory policies that now we know and we're suffering through, like the introduction of the universal credit, the introduction of benefit caps and benefit penalties for people who are not behaving in a particular way. I was writing about those from an emancipatory disability perspective as a non-disabled person, which makes the whole process of writing very complicated. And I had a long methodology chapter explaining why I dared to write emancipatory disability research as a non-disabled person. Right? I was kind of warned, if you wish, even told off on a few occasions by colleagues that I'm too much of an activist and not enough of an academic. And there were a few, questions about my objectivity, about my commitment to facts. So I used to defend myself and say things like I would never fabricate statistics, I would never fabricate facts. I would certainly entertain the opposing view, and I would engage with criticism and with critique, and I would reflect on my own positionality in my research and the shortcomings, of my approach. But it's my firm belief, and that's what's been a uniting thread, a common thread throughout all of my experiences, is that when you witness human rights violations, such as the brutality of a welfare reform designed to punish disabled people, I see it as part of your responsibility to make your research a very targeted intervention, to make your research a useful tool in the struggle for social equality. I don't think it's objective to spend some time thinking, is the welfare reform bad? Yes, it is extremely bad. It's extremely punitive. It's extremely unfair, and it's counterproductive. And it's making disabled people poorer, and in many instances, it's killing them. So I didn't really waste any time or energy in objectively looking at how bad the welfare reform was. I just thought I better put in whatever energy and knowledge I have into coming up with some sort of a contribution to resisting the welfare reform and, the Tory-led austerity. I better put whatever skills and whatever knowledge, whatever experience I've picked up over the years towards that struggle to make myself available and useful to the disability rights movement. So in that sense, for me, the production of knowledge is a little bit political. It's committed. It's targeted intervention. It's tied up with the struggle that happens outside of academia as well. What that has meant for me is long and often not particularly fruitful debates about, is my writing accessible for the very people that I'm writing for? How do I square the circle of working in academia, for example, where much of the stuff we publish is behind paid walls, accessible only to other academics, when in reality we want to make sure that our research and our contributions are easily accessible for the very people who need them. What language do I use? Is my language inclusive? Is my language accessible? Is my language authentic? Is my language empowering? A lot of questions that I ask myself whenever I write. So just to give you, for example, just a practical example of the type of stuff that I've done using my legal education to advance the struggle. And I'll stick to my example of disability rights because this is my passion. Both my parents are disabled. And again, this is an example of me blurring the line between the personal and political. I grew up in a household which was very political. Both my parents would be social justice advocates in their own rights. And I grew up within the social model of disability, which essentially says that society presents barriers to disabled people which constitute disability as opposed to an inherent flaw of the body or the mind, which is what we would call the medical model of disability, for example, or the individual model of disability. I grew up hearing my parents talk about the barriers that they've encountered in education, in their personal lives, in their professional lives, from a young age, long before I knew what the social model of disability was. So then when I became an academic, I thought, all of this is making sense to me. The dots are connecting. I know exactly what it is that I want to write about. I know precisely where I want to throw my passion and efforts in. And I chose to write about disability from a very personal and from a very political point of view. I was critiquing, to use a Foucauldian term, the welfare reform policies, not just as austerity that leaves disabled people poorer and doesn't fulfill what the Tory government at the time was boasting about, which was saving the taxpayer a lot of money. But these welfare reform policies were designed to punish disability as social deviants because they were both constructing disabled people as these benefits grounders, as these generations of unemployment, generations of irresponsible behavior. So these welfare reform policies and mechanisms for assessing disability were constructing disability as social deviance and then promptly proceeding to punish it. So you create this dichotomy of disability where either you have disabled people as these tragic victims of their own circumstances, either their failing bodies or their failing minds, and you treat them as these tragic victims accordingly. You keep them on minimal state support and you expect them to be grateful for the pittance that they receive. Or you treat them as the dangerous deviants that they are. Dangerous because, you know, whilst all the good taxpayers are trying to get a mortgage, you know, live responsibly, earn a lot of money, here are these people just expecting to get a lot of benefits. So I was writing what is sometimes referred in disability scholarism as emancipatory disability research. It's a little bit retro, it's a little bit 60s, it's a little bit radical Marxism from the 60s and 70s. That type of research, but it's very simple. The premise upon which emancipatory disability research is built is quite simple. Your main two tasks are to speak truth to power and to injustice, and to change the relationships within research, where disabled people are no longer an object or a subject of research, but an active participant, the leader in disability research, that they get to determine what the problems for and of disability are and what the solutions should be. Now, I can't say that I did that because, again, I'm a non-disabled person, but I certainly left 20 pages of my PhD explaining why I understand the ethical conundrum here. What I'm most proud about is, I guess, the end of my PhD, which was discussing resistance. And I really think that's the beauty of using your legal education or using whatever tools you have developed over the years as, you know, as a social justice activist. I discussed resistance. How do you resist that kind of responsibilization that the welfare reform presents? And as a typical academic, I will say there is a paper you can read that I co-wrote with Dr. Bausok from University of Sussex. And it's very much about the type of resistance, disability resistance, that I think is beautiful. At a time when the Tory government is screaming at you that you're a benefits grounder and you should get off your ass and get a job or else. That's obviously, I'm simplifying for dramatics today, but that's more or less the message, you know, of things like the universal credit and benefit sanctions. At a time when the government is bullying you into paid work, people choose to volunteer. People choose to join a grassroots theater group. People redefine the meaning of work. And I think that's a beautiful resistance. Obviously, I'm simplifying now my own work, but if you're ever interested, go and read that paper. So there's so much about academia. Obviously, after academia, I transitioned into the NGO world, and I do feel quite good in the NGO world. It comes with its own problems, but there is also this freedom honestly a little bit of an expectation to continue being quite political and quite determined and targeted in your writing. For example, the first job I got after the PhD was in this wonderful disability charity called Disability Action and this is where I truly saw what it means to use my legal education to advance the cause of disability justice. I was employed to be a researcher on a very radical disability-led project, co-produced disability project, examining how attitudes towards disabled people affect their access to health and social care. I know it sounds a bit weird, but I genuinely thought of myself as an expensive human pen. I was there to, if you wish, take the raw experiences of discrimination, isolation, marginalization, and work with them and put them in a type of research document that is compatible with, I suppose, academia. Because we did end up writing a beautiful report with my colleague, Darlene Corey. I'll see if I can share a link about the final report from that beautiful project. But this is where I wasn't contributing any personal lived experience. I was surrounded by the most amazing disability advocates with their own personal experience, who knew exactly what the problem of the system was. So I wasn't contributing that. I was literally contributing skills and knowledge of writing to a high standard, to getting stuff published, to getting stuff to a broader audience. And it was amazing. I really saw what my toolbox, my little modest toolbox of ideas and skills can contribute to the struggle. And I'm proud to say that several years down the line, coming in and out of academia, the attitude is still the same. I use my legal education to question authority, to speak, I suppose, truth to power, to use that cliche again, to deconstruct assumptions, whether it's about disability or whether it's about racism and anti-racism work. It's to dedicate all of the energy and mental capacity that I have, not so much to knowledge for knowledge's sake, but to knowledge and skills for the sake of fighting for human rights, justice, and equality. Claire, I'm not sure where I'm going with time, so give me an indication if you want me to shush now, because I
Yeah,
can.
Ivanka, maybe about another 5 minutes. Is that okay?
Oh yeah, that's fine. I mean, I don't have much more to say. Maybe
Okay.
I just wanted to say if I've experienced any barriers as a woman, um, and as a migrant, and what needs to be done, I suppose, what I think should be done further. In fact, my barriers as an able-bodied white European Union migrant, I don't think I'm interesting to discuss. So I don't actually know what to say about them. Yes, of course, women in academia face a number of barriers. Migrants in academia face a number of barriers. I think I also added the barrier of doing political type of research and also being political myself. Obviously, I don't know if it's that obvious, but I'm clearly a raging lefty lunatic. So I think there was adding this additional kind of barrier to face. People would be like, interesting, a young woman and with an accent, yet look at the politics. Perhaps it's a perception, but I certainly power through. What I think needs to be done, what I think is a more interesting and important question is what needs to be done further in terms of advancing or using our legal knowledge to advance social justice. I think more relationships need to be forged, particularly for people in academia. Sometimes academia works in isolation. It works for its own benefit. We go through particular motions. We write about some of the biggest problems of our time. We all strive to target and aim our research towards providing clarity and possibly even solutions to some of the biggest injustices. But sometimes the collaboration is not great. So I think better relationships have to be forged between academia and, for example, the grassroots activist world, or people with lived first-hand experience of injustice and marginalization or discrimination. And I don't mean including them kind of symbolically in our focus groups and in our engagements, but actually co-producing with them, which I understand as going over with a blank sheet of paper and saying, tell me how I can be useful here as this academic that I've tried to become over how many years. So more relationships, more productive relationships can be built and need to be built in order to ensure that the voices who are normally silenced and marginalized are not just included, but are actually leading the process of producing knowledge and pushing the boundaries of knowledge and research. I think that's an important thing that has to happen. And Claire, I don't know what else to say. Maybe if there are questions, I can go back to my rambling thoughts. I hope that was okay.
That was brilliant, Ivanka. Thank you so, so much. That was, as always, a fascinating talk by Ivanka. Our two speakers have a little bit more time today because one of our speakers unfortunately couldn't make it. So Ivanka didn't run out of things to say. It was just that she had an extra few minutes if she had wanted them. But thank you, Ivanka. So we are going to move next to Mairead Enright. So Mairead is a reader in feminist legal studies at the University of Birmingham. She often works along with activists for reproductive justice in Northern Ireland and in Ireland, and is a founder member of the group Lawyers for Choice. She's a board member of the Irish Family Planning Association and a member of the editorial board of Feminist Legal Studies. Thank you so much, Mairead, for joining us today, and I'll hand the floor over to you with just another reminder that if everybody else could mute their mics while Mairead is talking. Thanks very much, Mairead.
Okay, maybe you could do something for me, Claire, first. I'm supposed to check that the audio is still good because it was a bit crackly during the test. Is it okay, or should I turn my camera off?
No, it's absolutely fine, Mairead.
Well, if it stops being fine at any point, just give me a shout.
I will do. Thanks.
Okay. So thanks very much for having me. I wasn't really sure for myself who the audience would be, so I've taken the unusual step for me of actually writing what I'm supposed to say instead of just rambling. So I might even finish. Thanks very much for me of this wonderful program. I don't know if I'm a legal change maker. I was trying to think about like what legal change making is, and there isn't like a bit of case law or a statute or anything out there that I could point to and say that was me or I changed that, or because I usually, if I can, work in groups and in collectives, that was us, we changed that. I did qualify as a barrister some years ago now, 2006. I never practiced. That would have been a surprise and a disappointment to my law student self, but it hasn't been a disappointment to me in the long run. But because I never practiced, I've never brought a case, I've never written an amicus brief, I've not been cited in any major judgments. Sometimes my work is mentioned in the Oireachtas, but usually by opposition TDs and senators, and then who are often ignored by the government. So I'm often around when the law is changing lately, but I'm not the person who made it happen. And in relation to abortion law, both North and South, and I'm going to mostly talk about the repeal movement in the Republic in 2018. A lot of the writing that I've tried to do, particularly since then, and I have a few pieces coming out kind of making this argument, but I had a piece with Fiona de Londres and Catherine McNeely in the Northern Ireland Legal Quarterly where we made this argument together. It's the organisers of these campaigns who make legal change happen, and most of all, women who had been denied legal abortions in Ireland and Northern Ireland, and who shared that experience with others, who joined campaigns and so on. In our view, they're the main people who made the legal change happen, albeit not perhaps in the formal way that we usually would teach law students. But maybe that's the first thing I would say, is that like when I write about social movements and legal change, like I'm very much adhering to that kind of feminist theory of legal change that tries to be attentive to collectives and to the very ordinary kinds of labour that ultimately make radical law reform possible. So I don't think I'm a legal change maker. I think I'm probably just a person who knows a fair amount of law and who has been fairly fortunate to be asked occasionally to work with movements and campaigns who in their turn have made not just legal change, but something akin to revolution. So Claire asked me to talk about, or I said to Claire I might talk about Lawyers for Choice and our role in the campaign that led to repeal of the Eighth Amendment to the Irish Constitution. And many of you will know that that was the amendment which almost completely prohibited abortion access. And when I kind of think back on that time, and it's only 2018, but it feels like a very long time ago, so much has happened in the interim. Like, I really do think we were part of something revolutionary. And that's not just the law, right? Like, it is kind of miraculous and revolutionary that in parts of County Kerry, where I'm from, you can get an abortion in early pregnancy relatively easily. That's miraculous, albeit the legislation that enabled that to happen was imperfect, was disappointing, and we're still campaigning to have it changed. But I say that it was a revolution because the experience of the wider movement was revolutionary. And we could kind of feel happening this really profound, albeit incomplete shift in how we spoke about women and women's experiences in Ireland, and being part of that process was one of the great experiences of my adult life. So for those of you who would like to be in a revolution, if the opportunity comes up, I would highly recommend it, 10 out of 10. So I'm not speaking on behalf of Lawyers for Choice today. I'm not necessarily the best person to do that. Other people who were in Lawyers for Choice with different views and memory.
Mairead, Mairead, I'm really sorry to.
You want me to turn the camera off?
Yeah, sorry, it's the crackling has started all right. Sorry to interrupt you, Mairead.
Okay, is that any better?
I think so, yeah.
Okay, so I'm not kind of speaking on behalf of the others. I think the reason I'm here talking about Lawyers for Choice is that I have spare time on a weekday at the start of the academic term. So here we are. So if you don't know what Lawyers for Choice was or is, it's a group of mostly legal academics, some practitioners, with an interest in reproductive justice in Ireland. More of us are based outside Ireland than within it, as it happens. But that's probably got more to do with like academic job opportunities and age and so on. We were at our most active in 2017 and 2018 during the repeal referendum, and we worked for free alongside all kinds of pro-choice organisations, and we worked with pretty much everyone who was taking a pro-choice position, including, especially by the end, politicians from all parties. And there were two main things we did. One was that we provided strategic, everyday legal advice if we were asked to for pro-choice organisations. And that could be anything from discussing, proposals for legislation to like getting a call on a Sunday afternoon saying, we're thinking of having a protest in this place, will we be fined? But the main thing we did was we were producing public legal education materials that we tried to tailor to what was happening on the ground. And of course, 2017, 2018, changes are coming kind of thick and fast. So we were trying to be very responsive and very flexible. Some of the things we did, when I talk about public legal education, what I mean is taking the legal research that we were doing and translating it so that it could be used by as wide a number of people as possible for a range of different campaigning purposes. So we had a very strong social media presence where we were responding to news stories and developments. We were live tweeting legislative debates. We were also doing talks to a huge variety of audiences, everything from kind of local village halls to big conferences nationally and internationally. We provided people for street stalls during the campaign. We wrote op-eds, we did interviews, we were on podcasts. A couple of us, myself and Fiona DeLandris, wrote a small book on abortion law reform very quickly, which was intended to be accessible to non-academic audiences. We made badges, we drafted model legislation to show what the new abortion law could be like. We had a kind of FAQs abortion law website at one point. We turned the key points of that into a leaflet, and it was subsequently taken up by a range of other groups. For example, Deaf People for Choice turned it into a sign language video going through the main points. We trained other lawyers as the campaign got going, and we couldn't cover all of these events and activities ourselves. We trained other people to deliver talks across the country. And then in the aftermath of the successful referendum, we were working with TDs and senators to propose amendments to the legislation, most of which weren't used, but I think all of which are still kind of valid as we think about changing that legislation now that we come up to the kind of three-year review. And so what I wanted to kind of throw out there are kind of some of the things I learned from being part of Lawyers for Choice that I've kind of taken into other aspects of my work. And also, I suppose, when I was trying to summarize what they were, I thought I'd summarize them as, here are some things I've learned about how to give free legal advice to the revolution. So the first thing is just that idea of public legal education. I think this is a really valuable thing for lawyers to be involved in, to stop gatekeeping legal knowledge and to engage in discussion with people who have not been legally trained about legal issues that matter to them. And the repeal referendum was, a classic example or a classic opportunity for engaging in that kind of quasi-activist work, because people really wanted to understand in detail the impact that their yes vote or their no vote might have on women's healthcare, what legislation might look like, and so on. It was also important for us to participate as pro-choice lawyers, because at the time, and certainly in 1983, when the amendment was first inserted into the Constitution, there were some serious legal heavyweights on the anti-choice side, and we thought it was important to show that there were good, solid legal reasons for change from a pro-choice perspective as well. The second thing I learned is that you will learn to do better legal work and better legal analysis if you're part of a movement based on feminist politics. And it's not just the question of doing work that is responsive to people who are affected by bad law. You also learn an awful lot from working with people who are engaged in illegal or quasi-illegal activity to get around the law. I had done some work on the family planning movement in the South in the 1960s and 70s. And I could see comparisons between them and people who were bringing illegal abortion pills into the country. And there's a lot that you can learn from people who are working at the edge of the law. There's also a lot you can learn from working with feminist activists who don't have an awful lot of respect for law, like who would rather that there's no abortion law at all. So working with people who see you as an equal on a good day and a nuisance on others is very good for your kind of critical sense of re-examining your role in the role of lawyers in society, the kinds of arguments that you're putting forward. It gives you a good sense for the difference between a damaging and a constructive legal argument. Another thing I learned is that you should show rather than tell, if you possibly can. So that's where a lot of our kind of model drafting came from. A very good way to concretize a discussion about abortion rights or anything else is to write law with people, to show them what it might look like, to work through different options, to discuss the language. And that's not just kind of anti-gatekeeping work. It also, it pushes you into a kind of problem-solving orientation where you can really test the legal arguments that are floating around. You don't have to pretend that you know all the law or have all the answers. I'm still surprised that people assume that if you're a legal academic, you genuinely do know all the laws. And as the campaign was going on, we were getting questions about public order, we were getting questions about taxation of charities, we were getting questions about defamation law and what you could say on the television, what you could say on the radio. And these weren't things that were within kind of our natural bailiwick. That gave us opportunities to reach out to other people who were pro-choice, but not necessarily reproductive justice lawyers and so on. So not feeling that you have to be the person with the answer to everything, I think is a good lesson. I learned as well that you can talk about law in lots of different languages. So I think, especially on social media, Some of us made a point of like making jokes about the law and the legal process where it seemed appropriate, you know, kind of bursting some of the sort of sanctimonious approach sometimes to discussion of constitutional law. But also, you know, I remember at the time there was so much art, for example, being made about the Eighth Amendment and its impact on women's lives. I wrote a little bit about that subsequently, and that had a huge impact on me, just kind of thinking about how we can, it was just this unique moment of public interest in law from all kinds of people. And to just think about the different ways in which you can express the impact that law has on our lives. Maybe the last couple of things I'd say, just so that I'm not kind of repeating what's been said already, but one thing that I kind of wanted to say for maybe for like early career researchers or students who are kind of wondering how you get into that kind of work. I think Lawyers for Choice kind of taught us that like you don't need to be in a funded NGO to do that kind of public advocacy work, even though you do need to kind of know your place. But one thing we kind of weren't able to do as often as we might have liked to was get students involved a bit more. And part of that was, I kind of remember you would get emails saying, oh, this is really interesting. I'm a law student. I'd really like to help. And looking back on that kind of now, what I remember was we were so busy, things were happening so quickly that when someone just kind of gave a general offer of help, it was very hard to know what to do with them. And so I suppose my advice, if I have advice for anyone who wants to get involved in a campaign, is twofold. One, just because you have a law degree doesn't mean you have to join in with the lawyers. You can participate in all kinds of ways and you'll still have really valuable and helpful experiences. But if you do want to offer something in terms of legal analysis, tell the group what it is you can actually do. Tell them about the relevant training you've had. Tell them about the areas of law you know about. I think Maeve O'Rourke, who I know is speaking later, will be a very good person to kind of listen to about that kind of experience. And I suppose as well, be willing to be rejected. You know, it's okay if you offer kind of legal help to a group and they say, no, actually, we're grand, thanks. Find something else that you can do in the same movement. But maybe the last thing I wanted to kind of throw out there was that kind of issue that's come up already around, like, are you being too much of an activist, or do you devalue your expertise or your position if you're seen to be kind of out doing all this sort of woolly, fringy work? You know, is there something that you are you overstepping a boundary, and are you robbing yourself of the opportunity to speak in some ways by participating in this kind of work so publicly? And different people will take different views. But I think the one thing that kind of did occur to me when Lawyers for Choice was at its height was that some people were expecting their lawyers to look a bit different, speak differently, present differently. And they weren't entirely sure if they could trust our analysis because we were participating in this quite, you know, political, but sometimes quite irreverent way. We were offering legal analysis in that kind of voice. I don't think it damaged us, but I think it did remind us of something about legal culture. You know, that people expect lawyers, and particularly women lawyers, I think, to present in a kind of professional habitus that maybe we were deliberately not employing. And so the thing I might conclude on is just to remind everyone that, you know, if you do want there to be lawyers who are able to participate in these kinds of campaigns and help out, it's important to think about how we reproduce what's perceived to be professional or proper academic legal culture in the other spaces that we're part of. So even if you don't see yourself as a campaigner, you don't see yourself as an activist, if you're the sort of person who's more likely to donate to a campaign than participate in it publicly yourself, that's fine. But the other ways in which you can enable this kind of work to take place are by making sure that there is space for people who present non-traditionally, who do law in non-traditional ways, and to support the kind of critical teaching that enables non-traditional law to be done in the future. So I don't have a big finish. I think that's it. I apologize for the crackling audio earlier, and yeah, thanks very much. Happy to answer any questions.
Thank you so much, Mairead. That was honestly really, really fascinating and interesting to hear the different perspectives and the similar experiences that you both have, as well as then obviously the different experiences. Could I ask that if anybody has any questions, that you either use the raise hand function or you can pop it into the chat bar. I have a question that I can start us off with. I have a question for both of our panelists, but we might have questions coming in while I ask my question. So just kind of briefly, I have a question each, if that's okay. So Ivanka, to you, I would like to ask if you have any advice, particularly for our law students who are also passionate about various social issues. And Mairead kind of did touch on this towards the end of your talk, Mairead. But Ivanka, that you feel that some of our law students may be being told that they should be less activist in how they use their voice and be more objective. And so, what advice you might have from that and from your own experience? And Mairead, if you wouldn't mind, the question that I would like to ask you is that the repeal referendum was obviously a great success and a watershed moment in Irish history. But as a lawyer, you trade in facts to support your arguments. And so I just wonder how you felt at seeing some of the misinformation that was pushed on social media during the campaign, and I think that this is an issue that is not going to go away and it's going to, I suppose, just get bigger. And so if you're talking to, to everybody out there, how did you cope with that? Did you have any strategies, and just your experiences and feelings on seeing whenever you're trying to trade in facts to support your argument, but you're seeing a lot of misinformation coming from the other side? So maybe Ivanka, could we go to you first, please?
Sure. By the way, Mairead, your talk was really, really fascinating. And if there is time, I also have a question. I know, definitely not how conferences go. In terms of what I would advise students, from my particular perspective, which is disability studies, when people say be more objective, it's like they tell you be more scientific. I would like students to maybe spend some time thinking what is objective and what is science, because from a disability perspective, for example, objective science meant objectification of disability, commodification of disability, seeing disability primarily as a medical diagnosis, not spending a lot of time entertaining the idea that perhaps society has a role to play in marginalizing disabled people and pushing them to the fringes of society. So when people say be more objective, I wonder what it is that they mean. And I think we need to sit down and think historically, who had access to science? Who had the power to determine what is objective, what is proper, what is the right approach to doing research? Historically, look, or not even historically, right now, just take a look around of who's around you in the context of academia, who's very well represented and who isn't. So that would be the first advice I would give them. Just spend some time, essentially, be a little bit like Foucault. Obviously, I'm Foucauldian. That was my methodology at the time. Foucault spends an awful lot of time developing his idea of genealogy or anti-science. His whole work was about deconstructing the power of science that it poses over people. So that would be the first advice. And then the second advice is, we don't spend a lot of time, and Mairead touched on that, we don't spend a lot of time listening to the narratives or recognizing the experience and the knowledge that people bring to academia. I don't know, maybe I'm a bit harsh on academia, but often my observation has been that we use people whose experiences we want to relate to and write about as an addition to our work, as opposed to recognizing how much raw knowledge, how much experience, how much relevance they bring. I was really struck by Mairead saying, that she learned a lot from people who don't have much respect for the law, or who, work on the fringes of the law. And again, to put that through the prism of disability studies, that's the lived experience of disability, and the need to recognize it not as an additional source of information, but perhaps as the leading source of information. And when you relate to people's lived personal experiences, it's kind of difficult to then push the objectivity argument. So that would be the second advice I would give. Take full advantage of the enormous potential of transforming the notion of knowledge. Who possesses the knowledge? Whose knowledge has to be recognized and disseminated? That's what I would advise them. I don't know if it's a particularly good advice, though.
Thank you, Ivanka. It's always good advice. Can we go to Mairead with your question? Mairead, do you want me to recap that question?
No, I have it. I wrote it down as you were asking it. So yeah, I suppose one of the things in terms of Lawyers for Choice anyway was that ultimately we were relying on very high quality legal research. We were researching in those and publishing in those areas ourselves, and we were also able to fall back on a significant network of pro-choice legal scholars, genuinely across the world by the end of the campaign. So, and especially because we were working, within a human rights framework, like it is almost impossible now, while taking even a very mainstream approach to international human rights law, it's almost impossible to take an anti-choice view, and certainly impossible to stand by the Eighth Amendment, which almost never permitted abortion in the Republic. So we would say, and we weren't wrong, we weren't taking the piss, we would say, sorry, like this is just the law. This is just what's coming down from the various UN treaty bodies. This is what's coming down from the European Court of Human Rights. This is what's happened in other jurisdictions where these issues have played out in the courts and so on. So perhaps in a way, we had the advantage that perhaps feminist legal scholars didn't have, even in 1992 or 1983. We had the advantage that the law was very much on our side. The misinformation thing is difficult, and I don't have any particular expertise in that. But I think in terms of how we coped, I think there was a tension between the main body of the campaign. They had to make strategic decisions about when they would engage with the other side, because you've that tension between tackling their arguments that are working and that have some purchase in the public psyche versus like reigniting or legitimating arguments that have no basis in reality. When we set up, Fiona Delandris and I set up a website towards the end of the campaign where we would answer some questions about the future law, which were based in anti-choice propaganda. And we would really patiently and in detail explain why those things were not going to come to pass. So, for example, one of the arguments was that if you removed the Eighth Amendment from the Constitution, that fetuses would have absolutely no legal protection of any kind, that it would be absolute open season, right? And obviously that is not an argument that has been borne out by experience in any jurisdiction anywhere. And so you could just ignore it and say, well, that's nonsense. But we chose to go through it in huge detail. And actually, it was quite helpful for us to, intellectually or academically, it was quite helpful for us to take those arguments seriously for a little while and go through them kind of relentlessly. On the other hand, I can't pretend that we took some kind of hardcore liberal, sort of free speech, debate everything kind of approach. We didn't. I certainly, on Twitter, I used block lists, and there were block lists created for the campaign, because otherwise, especially when we were spending so much time on social media, and I spent a lot of time on Twitter as a distraction, and my phone lives in my pocket, and I think it's, you know, I don't think I have any duty to make sure that the thing that lives in my pocket is open to pictures of dismembered fetuses or whatever, right? So I had no problem signing up to those lists because it enabled me to kind of keep a clear head. And I know that lots of other people did that too. Maybe just the last thing, just to pick up what Ivanka said about, or some of what she was saying about objectivity and who you speak to and why. I do think some of the more powerful face-to-face experiences I had were talking to people, particularly people I respected, kind of where I'm from or in my family, my community, who wanted to vote no. And it was helpful to me to talk to them and figure out where they were coming from. And it informed how I would present the argument the next time that I did a talk in a similar kind of place. But the other thing to bear in mind is, like, in terms of objectivity or whatever, is that your engagement with the problem changes you. You know, it's not like you have a set of principles that you're already comfortable with, and then you go into a campaign or you go into interviewing people or you go into any kind of study and you know, your principles remain static, and then it's just a question of who you're going to apply them to, right? If you're doing it properly, I think your position will always be changing as you're going. I did have that question in a promotions interview though, actually. You know, how can you say you're an academic? How can you say that you are able to maintain objectivity when here in this application you're telling us about all this campaigning work that you're doing? You know, and I think, you know, that objectivity is not the same thing as neutrality. You know, that's the thing we have to bear in mind. Objectivity does not require us to both sides very serious human rights violations. Objectivity simply means that we have a good, solid, rigorous basis for the arguments that we're making, and that we're not kind of making stuff up. So the temptation was there, all right, like when you're dealing with a counter campaign that is very fast and loose with arguments and facts, it is tempting to kind of say, well, we'll just start making stuff up as well. But like, I think that would be the point, I suppose, at which you're probably losing your integrity and your credibility. So yeah, but the temptation was definitely there. It would have been good fun.
I can well imagine. Thank you very much to both of you for those answers. And I will, I know that we did have some problems with the chat bar, that it wasn't working during our keynote address this morning. So if anybody is trying to put a question in the chat bar and you can't, if you just raise your hand instead. So I don't think there's anything coming in. So quite a quiet and intently listening crowd, I think, that we have at today's conference. Ivanka, did you want to close with a question to Mairead then?
Yeah, just to pick your brain, Mairead, your brain, Claire, about something that I mentioned. I've been mulling it over, you know. In academia, especially as an early career academic, you're constantly encouraged to publish for an academic crowd, you know, to kind of prove yourself, to get the whatever the things that you need to progress further. At the same time, and I know that's a major thing for disability research, the whole changing of the mode of production within research, just producing things that are fully accessible, not just in terms of language, but in terms of being free and accessible for everyone. So I guess my question would be, what would we advise students or early career researchers who are activists in their heart of hearts and who wish to dedicate their work to a struggle for justice, but there is this tug of war between wanting to, you know, target your work towards ensuring that you have a job, but then also publishing things in accessible, free-for-all forums. I personally think it's incredibly important because, again, I remember when the repeal campaign was happening and a lot of us from the north came to the south to take part in that campaign. Some of the most powerful documents produced at the time had nothing to do with the law. They were certainly not academic papers, but it didn't take anything away from how incredibly necessary they were, not just in terms of informing and educating, but also in terms of sustaining that struggle. So it's just an open-ended question. What would we advise students in terms of this kind of where do we publish and how do we publish things?
Do you want to go first, Claire, or should
No,
I do
you
it?
no,
Should
you
do it?
work away, Mairead, because because I'll just keep
Okay,
an eye on the
yeah,
time here.
I guess the first thing is like I am very reluctant to give advice to early career researchers because the academic job market and working conditions have changed so radically, even in the last 10 years, right? And so I'm kind of acutely conscious that what some of us have been able to do is not like may not be possible in the same ways for others. So with that massive kind of health warning, I would say a couple of things. I think you can do both, and certainly I would do a fair bit of like blogging or whatever, or like writing for more general audiences on the way to writing a more complex or more academic-y paper. And I think you can certainly do it the other way around. You can summarize what you've written in this 10,000 word paper for a general audience afterwards. I think publishing open access is really important. And sharing, being able to share, the pre-publication version of whatever you've done. And so I would do that, and probably on a personal website rather than any of the sort of commercialized sites like academia.edu and so on. Feminists at Law is an open access journal that doesn't charge for people to submit to it. So I would find and focus on trying to publish in places like that. And increasingly, I think law journals are hospitable to stuff that is rigorous and based in sound research, but is written to be accessible to a wider audience. And my experience has been as well, actually, that like you can write something that is quite academic and you'd be surprised who reads it and gets it. That people who are working in various campaigns will be keeping an eye out for this stuff and will read it and will engage with it and have so much expertise on the issues themselves from their own campaigning that they, there isn't, for them at least, there isn't a significant barrier. But I do think, again, I don't know, kind of, are there, in terms of senior academics who might be in the room or whatever, I think it is very important to make clear that we support the work of junior scholars who are trying to do things a bit differently. And certainly the longer I do this job, I've tried to explore lots of different kinds of writing, not just the model legislation, feminist judgment stuff, the alternative executive summary to the Mother and Baby Homes Commission report that we did over the summer, and then writing for audiences in the arts and other places. Like, I think we need to promote that. The idea that if it's only in one of 4 law journals, or only the writing in one of 4 law journals counts, I think is increasingly outmoded. So I think it's that. I think it's just kind of, if people are early career researchers and they're wondering about where they can safely put their time and energy, I think, ultimately it depends on the kind of job you want, but I think you can build other kinds of writing into your writing process and it isn't a waste of your time, And the other thing is that, like, if you will be able to do a lot of the things that, like, employers don't realize they value these things until you're doing them, if that makes sense. Like, imagining the most conservative, like, if you're doing radical work, don't worry about making yourself attractive to an imaginary bogeyman conservative employer, right? You're not going to want to go and work there anyway. So don't forsake relationships that make your research and meaningful and valuable to you, to please somebody who you haven't met yet, to whom you have yet to send your CV, if that makes sense. Like the work will be authentic and satisfying and save you from a little bit of the depression and so on that goes along with a lot of this kind of work if you stick with it. So like, don't try to manufacture activist research out of what you're doing. It's not obligatory, but certainly don't pare it away, because once you do get settled, having those relationships will enable you to do more work with the academic platform you have if you get it. So that was a little bit rambly, but like, don't kind of cut your nose off to spite your face, I suppose.
Thank you, Mairead. That was, yes, some really good advice and an interesting question from Ivanka. We're almost out of time, but I think that what I would just add to Ivanka's question, with the caveat that I am an early career researcher, so perhaps don't listen to my advice too much, but I think what I would say, speaking more directly to our undergraduate students, is that you have great opportunities with your dissertations and things like that to kind of get a feel as to the, to what kind of Mairead and Ivanka were both talking about with that activist voice and objectivity and neutrality and, things like that. And it's one of my favorite parts of my job is the fact that I get to supervise lots of wonderful different research projects and dissertations where students come in, and they might come in at the very start with with the activist voice, and then they learn how to research and speak. And we had an event with Roddy Doyle a couple of years back, and he came in and spoke to students and about how they could use their law degrees for greater good in the world. And one of the things he said is that you don't have to have a large platform. You don't need to be speaking to hundreds or thousands of people. If you have something that you're passionate in, and then you're fortunate enough that you're studying something like law, and as part of that you get to engage in research in it, then just talk to your family and friends and the people who you do talk to, and that can make a difference as well. But on that note, I will wrap up because, again, as I said at the start, my computer clock is actually a bit off by about 5 minutes. So I think that I've actually allowed ourselves to run over by a few minutes. But thank you so very much to Ivanka and Mairead for a really interesting panel. And I'm looking forward to speaking to, or I'm looking forward rather to listening to our panel that begins at 1 o'clock with Professor Anne-Marie McAlinden, Dr. Maeve O'Rourke, and Claire McKeegan from Phoenix Law in Belfast. So we're breaking for lunch now, so you can just mute cameras, mute mics, and then we'll come back again at 1 for panel number 2. Thanks very much once again to everybody.
Thanks for having us.